Picture this scenario. You arrived in this country with nothing. You held down two jobs. You studied English during the evenings. You prepared for the civics exam until you could recite the first 10 amendments while half asleep. You lifted your right hand in a federal courtroom. You took the oath and somebody presented you with a certificate declaring you were now a citizen of the United States of America. That was 20 years ago. Last month, an envelope arrived. It came from the Department of Justice. It stated that the government was examining your naturalization file. It stated there was a question regarding an answer you provided on a form you completed decades earlier. You do not recall completing that form. You do not recall the answer, but the letter states you may have made a material misrepresentation, and the government is now petitioning a federal court to revoke your citizenship. The scenario I just outlined is a composite. I am constructing it from patterns documented by the New York Times, by NPR, and by attorneys interviewed by Reuters. No single individual in it is real, but the letters are real. The cases are real. And beginning in fiscal year 2026, the government has instructed its own officers that it wants a lot more of them. According to internal USCIS guidance first reported by the New York Times, in December of 2025, United States Citizenship and Immigration Services has directed its field offices to refer between 100 and 200 denaturalization cases per month to the Department of Justice. That is between 1,200 and 2,400 cases in a single year. Between the years 1990 and 2017, the United States government filed an average of 11 denaturalization cases per year. 11. If this new quota is fulfilled, the number of Americans who could be stripped of their citizenship in a single year will be more than 100 times the annual average of the last 3 decades. 26 million naturalized citizens are residing in this country right now. If you are one of them, or if someone you care about is, you need to comprehend what is actually occurring, what the law actually states, and what you can actually do to safeguard yourself. That is what this video covers. Welcome back to US Updates Hub. I am Timothy, and this channel is where immigrants, visa holders, green card holders, and naturalized citizens come to grasp exactly what is occurring in US immigration and exactly what to do about it. If you are new here, hit subscribe and activate the bell because the developments in this space are moving faster in 2026 than they have moved in decades. And I want you to possess the information before you need it, not after. Let me outline what is in this video. I am going to walk you through what the new denaturalization quota actually states. I am going to clarify who is really at risk, which is a much narrower group than the internet will have you believe. I am going to walk you through the legal standard the government has to satisfy, because that standard matters more than the quota number. And at the conclusion, I am going to provide you a protection plan with the specific steps you should take this month to secure your file. Let us get into it. To comprehend what is occurring in 2026, you have to comprehend where we have been. Denaturalization, the process of a federal court revoking someone's United States citizenship, has existed in American law since 1906. For most of that history, it has been utilized extremely rarely and only in the most serious circumstances. Nazi war criminals who lied about their past, human rights violators who concealed atrocities, people who committed fraud so deliberate and so material that a federal judge was willing to declare the citizenship should never have been granted. The figures tell the story. According to Justice Department records cited by legal scholars and the American Immigration Lawyers Association between 1990 and 2017, the government filed roughly 11 civil denaturalization cases per year. In some years, it filed fewer than 5. The tool existed, but it was treated the way Supreme Court precedent said it should be treated. The Supreme Court has emphasized in decisions going back to Afro-Yim versus Rusk in 1967, and more recently in Maslenjak versus United States in 2017, that American citizenship is a precious right, not one the government can revoke casually. That was the state of the law for most of the last century. Then in December of 2025, the Department of Justice and USCIS issued new internal guidance. According to reporting by the New York Times, NPR, and Reuters, the guidance directed USCIS field offices to refer 100 to 200 denaturalization cases per month to the Justice Department's Office of Immigration Litigation. That is the division inside DOJ that actually files the federal court cases. To fulfill those numbers, USCIS has reportedly reallocated staff and deployed specialized reviewers across approximately 80 field offices around the country. The agency is not creating new law. It is going back through existing naturalization files, some of them decades old, and searching for grounds to refer the case. Former officials have raised concerns. Sarah Pierce, a former USCIS official, told the New York Times that requiring monthly quotas that are 10 times higher than recent annual totals turns a serious and rare tool into a blunt instrument. Amanda Baran, a former USCIS policy chief, told the same newspaper that the Supreme Court has repeatedly stated that citizenship and naturalization are too precious and fundamental to our democracy for the government to take it away on their whim. Morgan Bailey, a former Department of Homeland Security official, told Newsweek that hitting these numbers through the normal legal process would be, in her words, virtually impossible. Here is why that last point matters. Even if USCIS refers 200 cases a month, every single one of those cases has to be filed in federal court, and every single one of those cases has to satisfy the legal standard the Supreme Court set in Maslanjak. The quota is on the referral side. It is not a quota on the court side. Most of these cases will take years. Many of them will fail, some of them will never get filed, but all of them will create anxiety. And that for millions of naturalized citizens is already the point. Let me break this down into the pieces you actually need to comprehend. I am going to address 4 things. First, what denaturalization legally is and is not. Second, who the Justice Department has actually stated it is targeting. Third, what the government has to prove in court. And fourth, what happens to you if the government wins? First, what denaturalization actually is. There are 2 kinds. There is civil denaturalization, which is the main kind, and the kind the government is expanding in 2026. It is a lawsuit filed by the Justice Department against you in federal district court. If the government wins, a federal judge signs an order revoking your citizenship. And there is criminal denaturalization, which happens after a criminal conviction for certain immigration fraud offenses. We are discussing almost entirely the civil kind. Civil denaturalization is not something USCIS can do on its own. This is the single most important thing to grasp about this entire policy. USCIS can refer your case. USCIS can investigate your file. USCIS can call you in for an interview, but USCIS cannot take your citizenship away. Only a federal judge can do that, and only after a full lawsuit with evidence, with a defense, with discovery, and with the government carrying the burden of proof. Your citizenship is not going to vanish in the mail. Second, who is actually being targeted? The Justice Department's internal guidance, as reported by the New York Times and confirmed by multiple legal analyses, identifies 3 priority categories for review. Category 1 is people who concealed criminal histories during their naturalization process. This is the old-fashioned core of denaturalization law. If you had a felony arrest that you failed to disclose on your N-400 because you thought it would disqualify you, that is the kind of case that has always been eligible for denaturalization. Category 2 is people who committed financial fraud, including Paycheck Protection Program fraud from the COVID era and Medicare fraud schemes. This is newer. The theory is that if you committed a large enough fraud, it may demonstrate that the good moral character you swore to during naturalization was not truthful. Category 3 is people with alleged connections to gangs or drug cartels, where there is evidence they concealed those affiliations at the time of naturalization. Notice what is not on that list. Ordinary tax mistakes are not on the priority list, although the government has publicly stated that serious financial misrepresentation can qualify. Political opinions are not on the list. Where you post on social media is not on the list. Having a foreign-born spouse is not on the list. Speaking a language other than English at home is not on the list. If you are one of the 26 million naturalized citizens in this country, and you disclosed your history honestly when you applied, and you have not committed a major fraud or serious crime since, the likelihood that the Justice Department is filing a denaturalization case against you is based on everything in the public record low. I am not saying 0. I am saying the system is not designed to come after ordinary people. Now, let me provide you a concrete sense of what these cases look like when they actually get filed, because the figures can feel heavy in the abstract. But the actual cases USCIS has publicly announced in 2026 tell you a specific story about who the system is actually reaching. In April of 2026, USCIS announced its role in the denaturalization case of a Nigerian national named Emmanuel Oluwatosin Kazeem, who, according to the Justice Department, was the mastermind of a multi-million-dollar tax fraud scheme. That is a Category 2 case, financial fraud, large-scale, post-naturalization. Also in April, USCIS announced the sentencing of a naturalized citizen named Nader Radovan Tomanovit, who was convicted of fraudulently obtaining citizenship after, according to the Justice Department, committing torture and war crimes in Bosnia. That is the classic category, the kind of case denaturalization has always been utilized for. In March, USCIS announced the denaturalization of Carlos Noe Gallos in Texas, who the Justice Department stated was a convicted child sex offender who concealed relevant information during his naturalization. These are the cases the government is choosing to publicize. Observe the pattern: large-scale financial fraud, serious violent criminal history, war crimes. These are not cases against ordinary naturalized citizens who filed their taxes late or received a parking ticket. That does not mean that Quota stays targeted forever. Civil rights attorneys have warned that as the pressure to fulfill monthly numbers increases, the cases will reach more marginal territory. Borderline omissions, old mistakes, paperwork inconsistencies. That is the concern for the next year and the year after that. But right now, today in April of 2026, the pattern of publicly announced cases is clear. Knowing that should change how afraid you feel. It should not change how prepared you are. Third, what the government has to prove. Here is where the law actually protects you. In Maslanjak versus United States, decided by the Supreme Court in 2017, the court held that the government cannot revoke citizenship for just any misstatement on a naturalization form. The government has to prove two things. One, that you made a false statement. Two, that the false statement was material to your eligibility for citizenship. Material means it actually mattered. It means that if you had told the truth, you would have been denied citizenship. That is a high bar. If you forgot to list a parking ticket from 1998 on your N400, that is not a material misrepresentation. If you misspelled the name of your high school, that is not a material misrepresentation. If your address history had a gap because you were couch surfing for 6 months 20 years ago, that is not a material misrepresentation. The government has to demonstrate that the specific lie you told actually changed the outcome of your case. The government also has to prove its case by clear, unequivocal, and convincing evidence. That is one of the highest standards in American civil law. It is not the lower preponderance of the evidence standard used in most civil cases. It is closer to the standard used in cases where a fundamental right is at stake. And you get a lawyer. You get to mount a defense. You get to cross-examine the government's witnesses. You get to appeal if you lose. This is not an immigration court proceeding where the rules are relaxed. This is federal district court, the same court that hears patent cases and securities fraud cases. The full protections of American civil litigation apply. Fourth, what actually happens if the government wins? If a federal judge signs an order revoking your naturalization, your legal status does not automatically become nothing. In most cases, your status reverts to what it was before you naturalized. If you were a lawful permanent resident before you became a citizen, in most cases, you become a lawful permanent resident again. What you lose is significant, though. You lose the right to vote in federal elections. You lose eligibility for certain government jobs. You lose the ability to sponsor some family members under citizenship preference categories. And most importantly, in the current climate, you lose your automatic protection from deportation. That is the piece that matters most right now, because once you are back to green card status, you are subject to the same removal grounds as any other lawful permanent resident. If the underlying fraud the government proved in your denaturalization case also constitutes an immigration offense, you could face removal proceedings after the denaturalization. This is why the quota matters, like even if most of the 200 referrals per month never result in actual denaturalization. Each referral triggers an investigation. Each investigation surfaces a file. Each file might reveal something unrelated to the original question that the government can use. The process is the punishment, as some civil rights attorneys have expressed it. And that brings me to the most important part of this video. What do you do? Here is what you actually do. I am going to provide you 6 concrete steps. Take notes. Step 1. Request a complete copy of your A file. Your A file is the alien file that USCIS maintains on you, and it contains every form, every interview note, every document you ever submitted to the agency. You have the right to request it under the Freedom of Information Act. You file Form G639 and you can do it for free at uscis.gov. Yeah, FOIA. Processing takes several months right now, so start today, not next month. Having your A file in your own possession means you know exactly what the government has on you before they come asking. Step 2. Pull out your N-400 application, the form you filed when you applied for naturalization, and read it line by line, every answer, every date, every address, every employer. If you kept a copy, pull it out tonight. If you did not, your A file will contain it. Read it with fresh eyes. Flag anything that is inaccurate, even if the inaccuracy seems trivial. You are not doing this to confess to anything. You are doing this so you know what the government has on paper, and so you can speak with an attorney about whether any of it creates exposure. Step 3. If you spot anything that concerns you, or if any part of your history makes you even a little nervous, consult an immigration attorney who specifically handles denaturalization defense. Not all immigration attorneys do this work. You want someone with federal court experience because that is where these cases get litigated. The American Immigration Lawyers Association has a directory at aela.org. Consultations are often free or low cost. Do this before you receive a letter, not after. Step 4. Keep your documents. Tax returns for every year since you naturalized. Pay stubs, leases, utility bills, anything that establishes where you lived, what you did, and how you earned. The government's case, if it ever comes, will be built on paper. Your defense will also be built on paper. Do not throw any of it away. Step 5. Be careful with any interaction with USCIS or federal immigration officers. If you are traveling internationally, carry your passport and your certificate of naturalization. If you are stopped by an immigration officer, you have the right to remain silent and you have the right to an attorney. Do not sign anything you do not understand. Do not answer questions about your naturalization history without counsel present. You cannot talk your way out of a denaturalization case. You can only talk your way into one. Step 6. Know the hotline numbers. The American Civil Liberties Union Immigrant Rights Hotline is 877-2736-2700. The AILA Lawyer Referral Line is 800-954-0254. The National Immigration Law Center has resources at nilc.org. Write these numbers down, put them in your phone, give them to your family. If something happens, you do not want to be searching them up under stress. One more thing. If you hear from USCIS or the Justice Department, do not respond without an attorney. I am not exaggerating this. A letter from the Office of Immigration Litigation is not something you handle on your own. The government will attempt to interview you. They will request you to sign statements. Everything you say and everything you sign will be used against you in federal court. Contact an attorney first, respond later. I want to close with something that I believe gets lost in the news cycle. You earned your citizenship. You earned it by doing every single thing the United States government asked you to do. You learned the history, you paid the fees, you passed the tests, you waited the years, you stood in a federal courtroom, and you promised to defend the Constitution of the United States. That oath was not a formality for you. For most of the naturalized citizens I have spoken with, it was the most serious moment of their adult life. That does not disappear because a memo was issued in December. The law of denaturalization in this country is strict. It is strict on purpose. The Supreme Court, going back more than 50 years, has built protection, after protection around naturalized citizenship, because the court understood that a citizenship that could be revoked easily is not really citizenship at all. Those protections did not go away in 2026. They are still there. They still apply to you. The quota is a policy choice. The Constitution is not. So yes, pay attention. Yes, prepare. Yes, get your files in order and consult an attorney if anything about your history gives you pause. But do not live in fear. Fear is what the quota is engineered to produce. Preparation is what defeats it. You are an American citizen. Act like one. Know your rights like one. Defend them like one. Before I let you go, I want to hear from you. In the comments, tell me this. How long have you been a naturalized citizen? And when was the last time you looked at your N400? I want to know how many of you still have it, how many have never thought about it, and how many are going to go dig it out tonight. Your answers help me plan the next video in this series, which will be specifically on what to do if you actually receive a letter from the Department of Justice. Share this video with the naturalized citizens in your family and in your community. Not to scare them, to prepare them. The only people this policy actually hurts are the people who hear about it too late to do anything. Subscribe to the channel if you have not already, and join the WhatsApp alerts at the link in the description, so you get the next breaking update the moment it drops. One important note before you go. This video is for educational and informational purposes only. I am not your attorney, and this is not legal advice. Immigration law changes quickly and every case is different. If this topic affects you personally, please consult a licensed immigration attorney or a BIA-accredited representative before taking any action. Thank you for watching. I am Timothy, and this is US Updates Hub.